which consists of the Incoterms rules applicable to sea transport and inland waterway transport. Under the FAS term, the seller is considered to have fulfilled the delivery obligation when the goods are placed alongside the vessel nominated by the buyer at the loading point in the port. From the moment the goods are alongside the ship, the risk of loss or damage transfers to the buyer, and the buyer also bears all costs from that point onward. An important practical note is that FAS is not suitable for containerized cargo. In container transport, the seller normally delivers the goods to the carrier at a container yard or terminal rather than alongside the vessel. In such cases, FCA should be used instead of FAS to avoid misunderstanding and risk. When applying FAS, it is essential to clearly understand the responsibilities of each party. The seller must carry out export customs clearance so that the goods are legally permitted to leave the exporting country. If agreed by the parties, the seller may assist in chartering the vessel, but this is not a mandatory obligation under FAS. The seller's core duty is to deliver the goods alongside the vessel, at which point the risk transfers to the buyer. The seller must also notify the buyer of the delivery status, provide information related to transport security, and supply any information needed by the buyer to arrange insurance. In addition, the seller must comply with transport security requirements up to the point of delivery. Regarding documentation, the seller provides the usual proof of delivery and, if requested, assists the buyer in obtaining transport documents. The seller bears all costs up to delivery, including the cost of delivery documents, export duties and taxes, and any costs incurred when assisting the buyer. The buyer, on the other hand, is responsible for entering into the contract of carriage and paying the full freight. The buyer must inform the seller of the loading time, place of delivery, vessel details, and any transport security requirements. Once the goods are delivered alongside the vessel, the buyer takes delivery and bears the risk from that moment. The buyer must accept the delivery documents provided by the seller and is responsible for import customs clearance in the country of destination. From the time delivery is completed, the buyer bears all subsequent costs, including import duties and taxes, transit charges, costs related to the seller's assistance, and any additional expenses arising from incorrect instructions, late arrival of the vessel, or failure of the vessel to take delivery as scheduled. Under the FOB term, the seller is considered to have fulfilled the delivery obligation once the goods are loaded on board the vessel nominated by the buyer at the loading point in the port of shipment. From that moment, the seller's delivery obligation is completed. This term is not appropriate when the goods are handed over to the carrier before being loaded on board the vessel. A typical example is containerized cargo, which is usually delivered to a container terminal rather than directly onto the ship. In such situations, FCA should be used instead of FOB. When using FOB, it should be noted that the seller has no obligation to charter the vessel. However, if the parties agree, the seller may arrange the carriage on behalf of the buyer under usual transport terms. Under FOB, the seller must complete export customs clearance and then deliver the goods on board the vessel nominated by the buyer. At the moment the goods are loaded on board, the risk of loss or damage transfers immediately to the buyer. Before delivery, the seller must properly notify the buyer of the delivery status, transport security requirements, and any information relevant to insurance if the buyer wishes to arrange cover. The seller must also comply with transport security regulations until delivery is completed. In addition, the seller must provide the usual proof of delivery or assist the buyer in obtaining the transport documents. In terms of costs, the seller bears all costs up to the completion of delivery, including costs related to delivery documents, export duties and taxes, and any expenses incurred when assisting the buyer. The buyer, for their part, is responsible for chartering the vessel and paying the full ocean freight. The buyer must take delivery of the goods and bear the risk from the moment the seller completes delivery. Another important obligation of the buyer is to inform the seller of the time and place of delivery and the vessel that will receive the goods. If the buyer is late or provides incorrect information, any risks arising from late arrival of the vessel, refusal of the vessel to take the goods, or delays in loading are borne by the buyer. When the goods arrive at the port of destination, the buyer is responsible for completing import customs clearance, As for practical notes when using FOB, this term applies only to sea and inland waterway transport. In practice, there are many FOB variations based on port customs, so it is important to understand how FOB is applied at each port. Therefore, transport-related terms such as FI, FO, or FIO should not be used together with Incoterms, as they are not part of Incoterms 2020. A particularly important point is that FOB should not be used for containerized cargo. Because container goods are normally delivered at a depot or container yard rather than directly on board the vessel. In such cases, FCA is the more appropriate term. In addition, lecturers and businesses should pay close attention to the agreed number of delivery notices and whether the seller is arranging carriage on behalf of the buyer, in order to avoid disputes. When we study the CFR term, cost and freight, the first point to understand is that this is a sea transport term under which the seller bears the cost of bringing the goods to the port of destination, while the risk transfers to the buyer as soon as the goods are delivered on board the vessel at the port of shipment. Therefore, under CFR there is a very clear separation between the point at which risk transfers and the point at which costs are allocated. And this is exactly the key issue that must be emphasized in order to avoid confusion in practice. As for the seller's obligations, the seller must first conclude the contract of carriage and pay the ocean freight in accordance with the sales contract. The seller is also responsible for completing export customs clearance. The delivery obligation is fulfilled when the goods are placed on board the vessel nominated by the buyer, or when the seller acquires goods already delivered in that condition. After delivery, the seller must provide the transport document, such as a bill of lading, enabling the buyer to take delivery of the goods at the port of destination. If the freight paid by the seller includes unloading costs, the seller must also bear those costs. On the buyer's side, the buyer is obliged to take delivery of the goods at the port of destination and bears the risk from the moment the goods are delivered on board the vessel at the port of shipment. The buyer must pay any costs that are not included in the freight paid by the seller. If the buyer fails to comply with the notification obligations under B7 of Incoterms, any additional costs arising from delays or errors in notification will be borne by the buyer. In addition, the buyer must complete import customs clearance and bear the costs of inspection in the importing country, except for inspections required by public authorities in the exporting country. With regard to transport documents, the seller must provide a document showing the date of shipment within the agreed period, enabling the buyer to claim the goods from the carrier and, if necessary, allowing the buyer to resell the goods while they are in transit. Regarding the obligation to charter the vessel, the seller must arrange carriage in accordance with the sales contract and the standards set out in Incoterms. This includes chartering a seagoing vessel suitable for the nature of the goods, ensuring that the vessel follows a usual route, and contracting carriage on customary transport terms. The seller must ensure that the vessel is fit to receive the goods, safe, and appropriate to the agreed schedule. Finally, it is important to stress a key point under CFR. The transfer of risk does not coincide with the allocation of costs. Although the seller pays the costs up to the port of destination, the risk passes to the buyer at the port of shipment. As a result, if an incident occurs at sea after the vessel has left the loading port, the seller still bears the freight cost, but the risk of loss or damage to the goods rests with the buyer. When we talk about the CIF term, we can see that its nature is exactly the same as CFR, with only one key difference. The seller must take out insurance for the goods and provide the insurance document to the buyer, although the seller bears the cost of carriage and the cost of insurance. The risk still passes to the buyer at the port of shipment, at the moment when the goods are delivered to the carrier or loaded on board the vessel. Depending on the agreement, under Incoterms 2020, the seller is only required to obtain minimum insurance cover, usually Insurance Clause C, unless the parties agree on a higher level of coverage. This means that even though the seller pays the insurance premium, the protection afforded to the buyer is relatively limited. However, CIF is not suitable for containerized cargo, because container goods are normally delivered to the carrier at a terminal or warehouse before being loaded on board the vessel. In such cases, CIP is a more appropriate term. A CIP can be used for any mode of transport and better reflects the actual process of container shipment. Under both CFR and CIF, although the seller must pay the transport costs to bring the goods to the port of destination, the risk relating to the goods passes to the buyer at the port of shipment, immediately after the goods have been loaded on board the vessel. The difference is that under CIF, the seller must additionally procure insurance for the goods and provide the buyer with an insurance policy or certificate. The purchase of insurance must first comply with what the parties have agreed in the sales contract. If the contract is silent, the seller must arrange insurance in accordance with standard principles. The insurance must be taken out with a reputable insurer for an insured value equal to 110% of the total CIF value, and in the same currency as the contract. The insurance to be obtained by the seller is minimum cover, corresponding to Clause C of the Institute Cargo Clauses. The period of insurance must also ensure that the buyer is protected against the risks of loss or damage to the goods throughout the transport, from the place of delivery to at least the port of discharge. The insurance policy or certificate must be transferable, so that the buyer can resell the goods if necessary. If the buyer wishes to have broader insurance coverage beyond the minimum level that the seller is required to provide, the buyer must bear the additional costs for such extended coverage.